How y'all doing? Today I want to answer a very common question that we get, and that is, what is my car accident case worth? We get this question a lot from our potential new clients and from our current clients as well. It's one of the most difficult questions to answer in our job. In the end, your accident case is worth what a jury will award you at trial. But that doesn't really answer your question, now does it? Before I discuss what your car accident case is worth, I want to walk you through a few things when it comes to car accidents, some rules of the road, if you will. The first thing you need to understand is that we always anticipate that your case is going to trial. We never bet on the fact that your case will settle. If we expected every case to settle, then we wouldn't be diligent in our work, and we could find ourselves unprepared in the event that the insurance company decides not to pay what your case is worth. Always anticipating that a case will go to trial means we try to determine what a jury will value your case at, because the jury is ultimately the one that makes that determination in the event your case doesn't settle. Our due diligence, never settle attitude means that from day one, my firm will work hard to make sure we have all the facts necessary to prove that you were not at fault for the wreck. We will also conduct a thorough investigation to foray out facts and evidence that establishes that the other driver was negligent, or in other words, at fault. Another thing to keep in mind is policy limits. The insurance company for the at-fault party is typically only going to pay at most the policy limits of its insured. The minimum limits required under Texas state law is $30,000, but some policies, especially commercial policies, can be in excess of $1 million. Now, on to what you really want to hear about. What is my car accident case worth? Again, there's no bright line rule, but here are some factors that the insurance company will look at. First, paid or owing, or also known as past medical bills. This is usually the main thing that an insurance company looks at when determining how much they'll pay on a case. Often clients come in and they tell us that they've heard their case is worth 2 to 3 times the past medical bills. That's not necessarily so. We've tried and settled cases that resulted in less than 2 times the past medicals, and others that have resulted in over 100,000 times the past medical bills. The bottom line is it depends on the facts of the case. The insurance company will also take a hard look at the type of medical bills. They usually give credence to ambulance bills and to hospital bills. Who can dispute those, right? And they give less credence to chiropractor bills and therapy bills. Now, juries differ on their views on chiropractor bills and therapy bills. Some juries will award all bills, some not so much. Always keep in mind, though, that if your case goes to trial, the jury determines how much your case is worth, not the insurance adjuster. A second, future medical cost. These are another important factor that the insurance company looks at in determining the value of your case, but they tend to have less teeth than the past medical bills. Like past medical bills, the insurance companies value them differently than, or make a determination based on the type of treatment. For example, future chiropractic treatment is usually given less credence than future surgeries. Juries are fickle on this issue as well. It's hard to pin down what they're going to do. Venue is another issue that we look at. It's the county where the case will be tried. The insurance company keeps all kinds of statistics on venues. Insurance companies love to argue, for example, that Tarrant County is a conservative venue, and thus the juries are going to be more stingy. Now, while it is true that Tarrant County is conservative, we've found that Tarrant County jurors are great about doing what's right and compensating clients for what they deserve. Now, sometimes when you go to trial, it just comes down to likability and credibility. Which party does the jury like more? Which side seems more believable? Accordingly, insurance companies take this into consideration. If you have a slimy, slick defendant who would insist that the sky's green no matter what evidence is put in front of him, his own insurance company is probably going to offer more money to you than they would if their client was, say, Mother Teresa. Same thing holds true for the plaintiff. If you have an innocent mother of 3 who can't tell a lie, her case is usually valued a lot higher than a 3-time felon. Pain and suffering and mental anguish. These are additional categories that are typically pled for in a personal injury case. and something that we seek compensation for. As a general rule, insurance companies value these elements of damages far less than juries do. Typically, an insurance company's value of a case is done by a computer program. And while a computer program can calculate hard numbers like past and future medical bills, it experienced a lot of difficulty putting a number on pain and suffering and mental anguish. Thus, therapy and changes in life activities matter if the value is being determined by an insurance company. Picture this. When an insurance adjuster sits down to evaluate a case's worth, the adjuster sits in front of their computer and inputs data into an insurance computer program. After the data is all input, the program spits out a figure, which is the maximum that the adjuster can offer on the case. When it comes to calculating pain and suffering and mental anguish, the computer can't really analyze like a person can. It can't see the emotion that you show when you talk about your pain. It can't see the hurt. But the insurance computer will give you more compensation for pain and suffering and mental anguish when it notes certain things. For example, did you have to go to therapy for your injuries? If so, how many times? Was it a psychiatrist or a medical doctor, or was it a psychologist like a PhD? Think of each of these questions as a checkbox or a multiplier. A medical doctor or psychiatrist usually gets a higher multiplier number, whereas a psychologist, a PhD, gets a lower multiplier. The computer program also looks at things you could do before the wreck that you can no longer do or that you do with difficulty now. If we file suit on your case, at some point you'll give a deposition. During your deposition, the defense lawyer will undoubtedly ask you, "Sir, can you please list for me the things that you could do before the car accident that you can no longer do or that you do with difficulty?" It's a difficult question, and they ask as if you can list all these off the top of your head. The answer, it just goes on forever. Yet, the insurance company and the insurance defense drone lawyer expects you to rattle off these items one by one. After he's compiled a list of your quote-unquote limitations, he'll send it to the adjuster who will put the list into the computer. The computer will do a recalculation and it'll submit more settlement authority. Now, like I've said, it's hard to know the exact value of your case. A number of things are considered. At my firm, we do our best to get you every dollar you're due, and in the end, that just comes down to hard work and determination. As always, if you like what you've heard here and you want to know more, or you've been involved in an accident, feel free to give us a call at 817-820-0100 or fill out a free case evaluation online. Thank y'all.